what I want to talk about, and I want to frame this within the context of climate disruption. And I'm going to talk both about the challenges that are facing tribes in this country. And although I will not spend a lot of time on it, I do want to focus just a little bit on the issue of water in the West, since that is a recurring issue, and the Supreme Court just spoke on it last term. Okay, so what I'm going to do is first talk about natural resource management, what it means. I'm going to distinguish it between stewardship, co-stewardship, and co-management. And then I'm going to talk about Secretarial Order 3403, which the Secretary of the Department of Interior and the Secretary of the Department of Agriculture co-issued. And what that secretarial order does is to push both departments to identify and to begin acting on areas where co-stewardship is available, and to identify those federal lands where it makes sense. I'll talk about the active engagement of tribes, and then we'll look at the case studies. So the natural resource management primarily focuses on land, water, and soil, but it also, of course, focuses on other things, other kinds of flora and fauna, the animals, on management of wildlife, management of forest land, management of fisheries. All of these are part of the federal management, federal and tribal resource management. EPA has generally taken the lead in some of these areas, but obviously Interior has a large role to play, as does USDA, which controls the National Forest Service. It also implicates, and it's important to remember, it also implicates those private sector actors who either use federal lands or have assembled vast tracts of private land, which has implications for tribal resource use. Land trusts, which I'm not going to talk about in detail, but are an interesting topic in and of themselves. Land trusts are one of the mechanisms that the private sector has used to assemble vast tracts of land, and some of them have actually engaged in something approaching land back for some tribes, primarily in the Pacific Northwest, but also more recently in the Northeast. And then some groups like the Nature Conservancy, which is a large trust, has adopted a program of bison reintroduction and maintenance of bison herds in order to improve the quality of the plains and to increase the biodiversity. And just to give you a sense of how much land is controlled by private land trusts, an area equal to the size of Idaho is currently controlled by private land trusts. So it's in some ways it's an understudied area, but it's a major component of private land management. So you have the state and federal land managers. The federal land managers are the ones I'm going to focus on now, but you should pay attention to the ways in which the states manage their resources. And I'll talk a little bit about that when we get to the discussion of treaties. Stewardship. The departmental activities that fall under the rubric of stewardship involves the management, the conservation, and conservation, of course, is a technical term. The conservation and preservation of wildlife, the habitat for animals, and to control what are approved uses of the land, and to maintain those infrastructures that already exist or have historically existed for the management of vegetation, fish, wildlife, and other resources. Important in this is to recognize that the federal government, at least since 1906, has recognized the importance of protecting cultural resources as well as trying to manage federal lands for recreation and other activities. But cultural preservation remains an important aspect of the things the federal government takes into account. One of the things that they've tried to do recently is to increase the integration of tribal knowledge and experience into cooperative management agreements. So what the tribes have pushed for, and what the current order calls for, is for a movement away from the idea of co-management itself, even going beyond co-stewardship, to focusing on what they've called collaborative management. One of the reasons for this is the tribes have historically been unhappy with the way in which co-management has been carried out, primarily because it has been done without an adequate process for tribal engagement in decision-making at a point early enough to have a significant impact on decisions affecting the natural resources. So that's, I think, an important and critical change. It may seem like it's just a change in language, but the language matters, because the language actually does refer to a change in philosophy. So under the Biden administration, as I said, the Department of the Interior and the Department of Agriculture issued a joint secretarial order, 3403, which, as the slide says, it's an order to fulfill the trust responsibility to Indian tribes in the stewardship of federal lands and waters. Now, there's a couple of points about that I want to raise. One is that it clearly identifies the trust responsibility that the federal government has in relationship to the management of tribal resources. And what it suggests is that in order to fulfill the trust responsibility, the federal government, where it has the opportunity to, it has to use the concepts of collaborative management or stewardship in order to fully articulate what the duties the federal government has in relationship to the trust. Now, the trust duty is a duty that arose from the earliest days of the initial colonial encounter. the Supreme Court in the so-called Marshall Trilogy, the three cases that have outlined essentially the structure that defines the evolution of federal Indian law, explicitly identified a trust relationship between the federal government and tribes. Now, that's it's actually a complex idea, because it is, as you'll see, it's not immediately clear what the trust duty implies. It's not even clear whether the trust duty as expressed between the federal government and the tribal governments has anything directly in common with our normal conception of what a trust responsibility is. And I can answer questions about that if you like. Okay, so Secretarial Order 3403 requires the agencies to take into consideration tribal interests in federal lands, including those lands that are not technically within tribal ownership, but over which the tribes retain an aboriginal interest. So the land that the tribes will have a source say in protecting will be all of those lands in which there is a tribal interest that are managed by the federal government. So that the idea is that co-stewardship will apply to the federal management of these lands and will integrate tribal stewardship and empower tribal stewardship where it's appropriate, and it will require that the agencies, the DOI and USDA, report annually on their efforts to achieve the goals of the secretarial order. It means that you have to have a meaningful consultation with tribes well in advance of decisions. If the decisions the federal government is going to make has an impact on treaties or the religious rights of tribes, the principles of implementation that are contained within the secretarial order will be consulted. And if tribal co-stewardship is not permitted, there has to be a intentional consideration of the proposals that the tribe has advanced. So as you can tell, it's not a perfect arrangement, but it does recognize that the federal government has important obligations that go beyond just the what we conceive of as ordinary management of natural resources. It includes religious and cultural values, so, and that's actually critical. So the power for the president to create the national monuments arose largely because of the recognition in the late 19th century that that a lot of important cultural sites in the West were subject to depredation, destruction. Archaeological sites were lost. Graves were dug up. The remains of natives who were buried were taken, and it essentially complicated and exacerbated the exclusion of Native people from their historic lands. So the history and the legacy of exclusion of Native people from their Aboriginal lands, as well as in ignorance of indigenous knowledge in land management policies, drove Congress to pass the Antiquities Act of 1906. And it's the Antiquities Act that gives the president the power to create national monuments. So the Antiquities Act then gives the president the power, and how that power is going to be exercised is actually a critical element in the new policies. so that the incorporation of indigenous knowledge is important, especially in the context of climate disruption and how the way in which the knowledge that the tribes bring to it reflects the kind of long-standing relationship of the tribes to these places. So as I said, co-management is not a new idea, really, right? So Canyon de Chelly was created in 1934, and it is managed cooperatively by the Navajo tribe and the federal government, the BLM, the Forest Service, et cetera. Let me go back to this slide, because the Grand Portage National Monument is also a national monument that was created, although the opposition was sufficiently extensive that the management of it is done on a 25-year contractual basis that will be revisited, and it just demonstrates that the resistance is often at the local level, even where the federal government has made these decisions. Yukon Flats is one of the most important breeding areas for waterfowl in the world, and it's important to the native people in Alaska, and it's a national fish and wildlife refuge that controls development, permits tribes to continue to use it, but it's another example of the way in which its co-management existed. In some ways, a large number of the most important co-management experiments have occurred in the Pacific Northwest, where the tribe, there are 10 treaties up there that are commonly referred to as the Stevens Treaties, which guaranteed to the tribes off-reservation hunting and fishing rights. They're not the only treaties that do that. A number of treaties do that, but they guarantee to the tribes off-reservation hunting and fishing, and they create obligations on the state to act in a way that protects the resources and the values that are contained within those treaties. Now, the treaties, you have to remember, right, are constitutionally, right, within the supreme law of the land. So they are incumbent upon states to abide by, and they create a cause of action for the federal government to sue states where states act in derogation of the treaty obligations. But let me step back and refer to one of the earlier slides. One of the earlier slide on a Secretarial Order 3403 said that it's designed to enable the federal government to manage the trust duty relating to tribes. The nature of the trust duty is one that was developed, the trust duty was developed judicially. In the recent case of Navajo against Arizona, the Navajo sued to have the federal government represent its interest in the division of the land, of the water in the Colorado River between all the potential users in the Colorado River. And they argued that the federal government had a trust duty to defend the quantity of the water that the Navajo were entitled to. Now, there's something called the Winters Doctrine. And what the Winters Doctrine does is it says that where a reservation has been reserved by the tribe, that also carries with it a reservation of all of the water that's necessary to make the reservation land usable and valuable. So that the Navajo were merely asking for for the federal government to do that. The Supreme Court said or held that they didn't have that obligation because they read the argument that the Navajo were making in a way that the Navajo, in fact, didn't make, which was that the federal government would have to provide pumps and pipelines and whatnot to get water. All they were asking for was a legal identification and quantification of the amount of water they held and were entitled to under the Winters Doctrine, in a quite disturbing concurrence by Justice Thomas. Justice Thomas did something that was, to my mind, was quite disturbing. He suggested that there's no constitutional foundation for this trust duty, that he's not even clear that there is a trust duty that is greater than that articulated by the Congress. So if the Congress explicitly binds the federal government, then there might be a right. But absent a specific congressional authorization, Justice Thomas mused that the trust duty wasn't something that was actually real. So stay tuned. That's going to be an issue arising in the next, well, in the next generation, the next 10 years, in the next few years, who knows? But it's scary. All right. So let's be a little happier here to be talking about that. Let's talk about Bears Ears, because Bears Ears in some ways was the archetypal example of what co-management, co-stewardship is about. There are 13 tribes who have an interest in the land that's contained within the Bears Ears Monument. There were 5 tribes that were consolidated into the Bears Ears Commission. There's a intertribal council that allows the tribes to work out their own disagreements over how the land should be used. But that's just one party. You also had the federal government, the state government, and private stakeholders. And what the practice was to bring all of these stakeholders together and to generate an agreement that ultimately resulted in the creation of the Bears Ears National Monument. Of course, in the last administration, Bears Ears was significantly reduced, but the current administration has restored the Bears Ears to its former boundaries, and each co-management of Bears Ears provides each tribe a place, a way to engage in co-management of the resources, and it also integrates tribal indigenous knowledge in the management of this national monument. So the process of climate disruption, the risk, the threat of climate disruption is still with us. But what the movement towards co-management permits is for the tribes to actually engage with the federal land managers and other managers of the land to act before the crisis is irredeemable, right? So that it's not going to, stop climate change, but it incorporates those aspects of federal land management that will actually permit the tribes to take the action that they deem fit necessary to help avert those problems. You can see on this slide, I apologize for having a slide with so many words on it, but you can see from this slide all of the aspects of the Bears Ears National Monument Co-Management Plan. So with that, I want to thank you. And I'd be happy to answer any questions you might have. I don't even know how long I took, but I hope I didn't go too.
It was perfect timing. Thank you so much for that fantastic presentation. It was actually so great to hear about the tribal relations, because that's something that other speakers haven't touched on yet this semester. So thank you so much for that. Yeah, we have time for Q&A. Folks can go ahead and raise their hands. If you have a question, I can start the ball rolling while others are thinking. But I guess I don't mean to return to the doom and gloom, but I am curious about like what with the trust duty and the statements made, like what could possibly happen in the coming years if that is seen as like not viable law?
Well, two things. One, you still have the treaties, okay? And so the treaties provide a foundation for the to govern the relationship between the federal government and to create limitations of what the states can do that have an impact on tribal resources. So you have the treaties that are there. As a lot of the treaties, not all of them, but a lot of the treaties, both were stop. All of the treaties have contained within them some reserved water rights. So we know that. Not all of the treaties have provisions that permit the tribes to access or to use off-reservation resources. Many of the tribes do, especially the hunting and fishing tribes. They often are permitted to hunt and fish in their Aboriginal territories, even where those Aboriginal territories are no longer, quote, Indian country, but are in state hands or private hands. They also have generated, especially in the Pacific Northwest, agreements between tribes and the states where they jointly manage the resource to the extent that the tribes are required to engage with the states on that. The Supreme Court has held the states may not regulate the tribal use of the resources except to this extent. Where the state issues a regulation to control or preserve the species, right, then the tribes have to conform to that. So that, if there were a process where let's say salmon were being extirpated, the state might put limits on the amount of salmon that could be taken until the salmon were restored. The tribe would be subject to that as well, which I have to say, the tribes are not happy with. But it's an advance, certainly from the state's perspective. The state's actually made like one of the most absurd arguments you could ever imagine. Justice Sotomayor made them take it back. But what they did suggest was that all the treaty guaranteed was a right to fish. It didn't actually guarantee a right to catch fish. so that that if there were no fish, no, but they're still permitted to fish, no harm, no foul. Well, the absurdity of that, I hope, is obvious just by me stating it. Anybody who, any third grader should be able to understand that, right? And Sotomayor made sure that the Attorney General of Washington State understood the absurdity of the position, and he's retreated from that position. But it also, what that suggests, of course, is that the opposition to tribal management is profound. Now, there are things like the Columbia River Intertribal Council, right, which manages the Columbia River for all of the tribes up there. There's the Intertribal Timber Council, which manages or sets policy for timber management. So there are kind of intertribal organizations. But let's get back to your question. Your question is about the trust. That where there are treaties, there's clearly a federal obligation. Where there is no explicit language that would bind the federal government, but where the federal government chooses to act in a way that is consistent with what it defines as, and what the tribe defines as its interests, is where the question of the extent of the trust duty arises. The original opinions that I was talking about basically suggest this relationship. They said, look, the tribes ceded to the federal government land and retained land for themselves, right, in the process of the the encounter with Europeans. Because of the political relationship between tribes and the federal government is in a position, a superior position politically, and because of that position, has an obligation to act in relationship to those resources in a way that is beneficial to the tribes. Okay. What that means is where all the action is, right? My own position, it is not the law, but my own position is that the party that is best situated to say what their interest is the tribe. I mean, it seems to me not a crazy idea, right? But that's not the law. Okay, so that's where we are. The hard part is in the West is obviously going to be water and water management. So, in fracking, as fracking expanded in the Northern Plains, one of the big questions was, what's the impact of fracking on reservation aquifers, the water on reservations? Does the federal government have a role in regulating something that is technically regulable only at the state level, where it has an impact on tribal resources? That question's not been litigated, but it's certainly a live question. So I don't know if that answered your question or just made it worse. So.
It did. Thank you. And we do have time for a couple other questions if anyone has one. Go for it, Elena.
Thank you so much. That was a great talk. I am located up in Maine. I'm in Orono, so we're right here in Penobscot Nation.
The Penobscot just added the river as a citizen of its tribe.
Yes, I was actually about to drop a link for a movie about the river in the chat if people are interested in watching.
My good friend just completed a case that took 22 years to prevail, requiring the cleanup of the Penobscot River.
Yeah, okay, yeah. So yes, exactly. So I've been learning a lot about this lately, and it just makes me excited to talk about tribal relations, um, because there is so much work going on here. And so something that I've been thinking about a lot is, you know, you're talking about how tribes are able to sue, but I feel like I guess I'm curious about like what are those barriers that are keeping more tribes from actually challenging some of these resource decisions? And then like where have you seen success and what kind of resources kind of embolden and support tribes to be able to speak up and um, fight these cases? Because just watching the Penobscot and also just the relationship between Penobscot Nation and Maine, it seems like it's just been such a long battle and they're constantly like don't have the money to fight it. So I guess I'm just curious, like they're allowed to, but how can it actually happen?
Yeah, I mean you put your finger on a couple of really important points, right? One is that the conflict is always going to be local, right? Because tribes are on the ground, non-Indians are on the ground. The conflict often arises in that setting. That doesn't mean that the legal question is local. And so the first question that has to be answered is there a federal claim that can be made on behalf of the tribe that would enable the tribe to resist whatever it's trying to resist? As we've seen with many of the pipeline cases, right? The answer for that is often no, right? So even Standing Rock, right? The claim was that the pipeline was, while it was going through Aboriginal land, it was going through land that was not technically controlled by the Standing Rock Nation, right? And so there wasn't any kind of trust duty that would have triggered a right for the tribe to sue. Now, there are other ways you can sue, right? You can sue where there's a federal project that's going to affect the environment. There are many federal statutes that give you a potential hook to oppose the whatever the state or private party is doing, right? If there's federal resources involved, and where the tribe can demonstrate that it's been materially harmed in some way. So the environmental statutes provide another avenue in. So the Penobscot River case, right? That was really about the pollution in the Penobscot River arising from the lumber mills, right? The paper mills, and so it was a in some ways a Clean Water Act bill. Nonetheless, the Penobscot Nation was impacted, not to mention, Maine citizens who lived along the river, and a lot of the crabbers and lobstermen, right, from Penobscot Bay. And in fact, some of the most potent testimony in that case arose from the lobstermen, right, who said, it's not enough that you've now ruined my business, right? What you've done by hiding the fact of this contamination is permitted me to serve contaminated food to my family, my friends, and my customers, right? Which is a kind of guilt I now have to live with. So there are those kinds of issues that also arise, and there are allies, right, between the Maine citizens who are affected by it are allies with the Penobscot, just like in White Earth and other places like that, where there are pipeline issues, right? There may be allies that the tribes can work with to vindicate their issues but they're not necessarily going to be trust claims. I mean, my problem, and I apologize to all of you for, is I am a trust hawk. My view is that the trust ought to be, right, a substantial tool for tribes to control what happens to resources that affect the use of resources that affect them, right? And so I've developed a whole way of talking about that, but it's not the law. And you know, maybe if I train my students well enough, by the time I'm dead and their grandchildren are my age, it will be law, but who knows?